Welcome to the License to Lead podcast. I'm Patty Fay. This podcast is for physicians or anyone who thinks healthcare needs a transformation led by physicians. License to Lead means that physicians are charged with and must be in charge of guiding the vision and the culture of healthcare systems. Hello, everyone. Welcome to episode number 28 of the License to Lead podcast. This is Patty Fay. My guest today is Brad Adatto, an attorney who specializes in business law and especially the business of healthcare. He says that he has the healthcare industry in his blood, so he'll tell us more about that in a bit. Brad's law firm is Bird Adatto, which is based in Dallas, but serves clients across the country. His firm works with physicians and physician groups and others to build successful businesses and partnerships, create new entities, all the while carefully navigating all the federal and state healthcare regulations. My favorite line from his bio is that he decided to become a lawyer during sixth grade career day when he promised to represent his best friend, a future doctor. And indeed, that vision was realized, and that physician is one of his clients. Brad also co-hosts a podcast with Michael Bird, the other founding partner at Bird Adatto. And the podcast is called Legal 123s. It's an entertaining and excellent podcast, and I recommend it. Brad agreed to talk with me today about the corporate practice of medicine doctrine or corporate practice of medicine statutes. Welcome, Brad.
Thank you for having me. And I love the introduction. You plugged my podcast in the intro. That's excellent. Thank you.
I love your podcast. I think it is so helpful. I'd really recommend physicians take a listen. Our mission is to talk about the corporate practice of medicine statutes today. But before we dive in, is there anything more that you'd like to say about your work or your law firm?
Sure. I mean, I guess the background is 100% of what we do is we're a business law firm and all on the transaction side. But of our clientele, more than 80% fall in the healthcare arena. And this is not something we just arrived at. I've been practicing almost 24 years, and my entire career has been spent representing physicians and or the people who do deals with physicians. So an area we know pretty well. So I enjoy speaking about it since I feel like I've been around it my entire life now.
Great. Yes. I think I also read that your dad was a doctor. Is that right?
That's correct. Yeah. Both Michael and I are both our dads. We grew up in that world where our dads are both surgeons, mine being an orthopedic surgeon and his being a plastic surgeon.
That really does give you the inside picture. So to get right at it, what are the corporate practice of medicine laws about?
A lot of people, when they hear the terminology corporate practice of medicine, they kind of pause, or sometimes they don't understand what we're talking about. And the high level, it's a state law doctrine that's been around forever. And conceptually, in a high level, again, state by state's a little bit different, but it prohibits corporations or entities, or fast forward, non-physicians from owning and employing medical doctors or performing or owning medical practices. And so that's the concept behind it, meaning that, hey, you as a physician, you should only be working for physicians and you should not be working for corporations. And a lot of people say, okay, so show me, as you said, the statute in which they talk about it. Unfortunately, there's not a statute. Most states, there's no single statute say, here it is. It's coming from lots of different law sources. So it could be in a statute. A lot of times, then it has additional administrative rules that go with it. Then there could be your medical boards or your medical board examiners could come up with their own rules and regulations surrounding that. Finally, there could be attorney general opinions, depending on your state. And then, of course, finally, the case law. So when we are asked to look at a particular state, we are combining everything I just said. And then that gives us the big picture as to how does your state interpret the corporate practice of medicine.
And is there a wide variation from state to state, would you say?
Absolutely. The best way I can always describe it is there's basically three different buckets that this falls into. So some states are what we call the strict adherence to the corporate practice of medicine, meaning that only physicians can own medical practices. And in doing so, there's no combination of it. So let's just use New York as the perfect example. In New York, that's the way the law is written for that particular state. Then we could jump to states like California. So California is a second bucket where physicians and non-physicians can co-own a particular medical practice. And so and in California, if you read the regulations, it's restrictive, meaning that physician must own at least 51%, and other affiliated licensed healthcare providers, which is a defined term in their statutes, are also individuals who can co-own the medical practice with the physician. And then you can jump to states like Ohio, Oklahoma, Florida, where anyone can own a medical practice. So that's, again, the three different buckets as to how it's viewed. And then there's states like Missouri and Georgia, we call them like the squishy states, because the law and the way they're enforced is it's very vague, and it's almost nearly impossible to get it right in those states because of the way the law is written or how it's being enforced.
So by not being able to get it right, you're not sure until you're done or some legal action has been taken, whether you're on shaky ground or firm ground?
It's a fair question. So I always talk about when we go to states where it's not as clear as to how would the law be interpreted, we always go through a risk tolerance. So risk tolerance is some people are the people who are intimidated of stepping out of the shower in the morning, and some people will step out of a perfectly good airplane, hopefully with a parachute, and they're fine with that. And so when I have people trying to go to like Georgia, I can say, well, look, in Georgia, it's a state statute. The state statute is very clear that only physicians can own a medical practice. However, if you go to Georgia and you speak to any healthcare attorney in Georgia, they'll tell you, yeah, but that's never been enforced. And if you talk to their medical board, they only care, which is a very important aspect of any of these things, that so long as the physician's in charge of medical decisions, they really don't care if it's an LLC. That's their medical board's position today. So going back to your question, if you were saying, well, Brad, I'm thinking about going to that state, what should I do? I would walk you through the process and say, well, that's the medical board's opinion today, but tomorrow, a whole new medical board could come in and they could decide to make you the example. And so that goes back to the risk as to understanding you, the physician, saying, how comfortable do I feel being employed either directly or indirectly via, medical director agreement or independent contractor agreement. Some of my docs say, I'm comfortable with it. Some of them like, no way, I want to do it right. Tell me how to make it happen.
Just for some context, I guess, this is a little bit unusual in medicine among professions. I don't know that there's anything exactly like this in accounting or engineering, but there is in law. Is that right?
A little bit. I mean, a physician, if you want to go practice in Texas, is a process that to go through to be licensed in that state. That's the same thing with law. So if you want to be licensed in Texas or Louisiana or Mississippi, here are the rules and regulations for you to be licensed in our state. Part of those licensing requirements are you have to abide by our rules. So a lot of states, similar to the corporate practice of medicine, there's the corporate practice of law. So non-lawyers in Texas or Mississippi or other states, they can't employ lawyers. So very similar rules, meaning that if it happens, you are now in violation of your state laws. And so it's very similar to, a lot of people think it's just the physicians that handle this, but it's also other licensed professionals that you look to. I think one of the few states that allow other people to co-own a law firm, I believe, is the District of Columbia, where non-lawyers can co-own with lawyers. It's one of the few states I'm aware of.
We want to really get some idea what's important for physicians and physician leaders to know about the corporate practice of medicine. And if you're going to point to a couple of things that are critical for them to understand, what would you say those things are?
The first thing I would say is if you're in a state and you're uncertain, you definitely want to hit the pause button when a non-physician approaches you and says, hey, I'd like to do a deal with you, doc, and where you do A, B, or C. And the reason I say hit the pause button is every state's different. So depending on what state it is, you may be fine. And we're not going to obviously be able to cover all 50 states in this podcast, much less will I be able to remember every single one of them off the top of my head. We have clients all across the country, so some I'm just more familiar with than others. So let's hit the pause button. And when we hit the pause button, you want to then say, okay, let me reach out to healthcare counsel and say, hey, this non-physician approached me to do a deal. And that deal could be as simple as they want me to be a medical director for this clinic. They want me to be a medical director for their lab or for their ASC. How does that work in my state? Or they want to co-own a medical entity with me. How does that work in the state? And so that's the pause button where a lot of docs assume, and a lot of non-physicians assume, well, everyone's doing it, it must be okay. And that's not the scenario. And so we're business attorneys and we represent physicians, but we also represent them in front of medical boards. And so a lot of times when we're telling someone to pause, it's because we've seen this happen in that particular state as to how a doctor did get in trouble for potentially violating the corporate practice of medicine of that state. And so a lot of docs are like, oh, I don't think it's a problem because everyone's doing it. The answer everyone's doing is not the best answer to go with because unfortunately, there is no safety in numbers. When the medical board decides to pick on you, you're jeopardizing your license. And so we want to make sure you're doing it the correct way.
So I'd like to come back to this in a big way as far as the ways that physicians can get into trouble with, I've heard it referred to as aiding and abetting when it comes to violating corporate practice of medicine statutes or laws. But a bigger question for us to frame things with might be, if it's a strong corporate practice of medicine state, what sorts of things are physicians supposed to be doing for themselves as opposed to allowing someone else to be making those particular management decisions? Or how would a medical board decide that this business does not have physician leadership?
The states that look for this, the first thing they look for is this an absentee physician? An absentee physician is someone who is, air quotes, the medical director or air quote, the co-owner, but has no idea about the clinical decision-making occurring at that particular facility. They have no idea what the equipment is. They have no idea who the employees are. They literally are just people collecting a paycheck or mailbox money, and they have no processes they've put in place. Some of them might not even have the skills to oversee the services being rendered there. So the investigations I've been pulled into, that's one of the easiest ways for them to say, wait a second, doc, I see that you are an ER doctor, but they're performing all these cosmetic services at this facility. Tell me your background in cosmetics. Mm-hmm. And it's radio silence, right? And meaning that the doc knows all about taking care of people in emergency situations and dealing with keeping them alive. But the moment they start putting fillers, Botox, and lasers on them, they've never had 1 second of training on that. And so medical boards frown upon that. And all the doc is just a, quote, medical director to the non-physicians. And non-physicians can be your RNs, or you're even sometimes, depending on your states, your NPs and PAs, depending on if they have independent autonomy or not. But those individuals who just want to partner with that doctor so they can say, again, air quotes, they're compliant, but they're really not. And so I always tell doctors when they get called up to be a medical director to do these business, look, you are putting your license up. And I know everyone I know, including myself, who had to get licensed in a particular state, you work pretty damn hard to get it. And you need to think about, how do I want to protect it? So let me pause for a second and say, I'm not against doing these deals. I have doctors who do deals all the time, again, in multiple different states. Let's make sure we have eyes wide open. We understand what we're entering into. What are you expecting to do? So this is something we call the form and substance. Form, this is a medical director agreement. Substance, these are the things you're going to do, and you're going to do them, and you're going to get paid to do them. And so we always make sure with our clientele, or anyone should pause again and say, okay, they're going to pay me $1,000 a month to do A, B, and C. Am I going to do A, B, and C? And if I'm not going to do A, B, and C, why the heck am I going to put my license up for $1,000 a month? And again, so you got to think of bigger picture issues when you're being asked to do these deals. And unfortunately, a lot of docs just don't think about it because, quote, everybody's doing it.
I've heard the term captive physician. For instance, in a private equity firm, they have one physician who is friendly to the private equity structure, but the other physicians may or may not be. But that one so-called captive physician is the one who covers the bases as far as this need for a physician to be in charge. Is that what you're talking about?
That's partially it. Yeah. So that could be it. There's different versions of this. So there could be a single entity in which the doctor's a part of. When the private equity comes in, often they do have their friendly physician who is the physician who owns the practice and helps employ the practice. And if they're doing it correctly, is that physician is an active participant in the medical practice. And so let's be clear, that doesn't mean that they're actually rendering the actual services, but they're definitely overseeing what services are being rendered there. Do they know who the doctors are? Do they know their skill sets? They're on the medical board committee, if there is such one. They are helping determine the proper labs or whatever it is, because that's, again, going back to they're engaged in that practice. Again, private equity, when they do come into these deals, where I've seen it go awry is private equity shows up, then they start making all clinical decision-making. So let's go back to what we said in the very beginning of this podcast. what is the core practice of medicine doctrine? The doctrine is that physicians should not be working for corporations. Private equity is corporation. And so the moment that those clinical decision makings are being removed from the hands of a physician and being made by non-physicians, they have now stepped over the line. They, being the private equity, has stepped over the line as to where they should be standing. That's different than business decision. Where should I lease a space? Or what should be the trade name? Or what should be the way we negotiate A, B, or C? If you're a doctor and you're in a facility and they're like, all right, doc, you must order the suite of services for every single patient that walks in, which is a case I'm part of right now. And the doc's like, well, that's ridiculous. I would never order that suite of services because that's not necessary for when this patient came in. All I need to order is this. And then, of course, it turns out it's because the private equity owns a lab, or they own a pharmacy, or they own a DME company. And so they're pushing the docs in directions they shouldn't be pushing them in. And so that's, again, ultimately the decision-making of that physician is what the medical board will hold you to. So you, the physician, you have to abide by those rules that, hey, I am the decision maker. I'm determining what's best interest of this patient. And if you're not doing that, again, that is where you're stepping over the line and allowing your license to be used by unlicensed individuals.
So the rate of burnout is so incredibly high in medicine, and it's often attributed to the corporatization of medicine and getting into these scenarios where physicians are working inside of a corporation, and then pretty soon they're on a hamster wheel schedule. Mm-hmm. They're not hiring their own staff. They're not making the decisions about equipment and that sort of thing. How is that legal?
So there are two ways in which it can be done legal. Well, so let's go the easiest one. It's a state like Ohio where anyone can own the entity. So that's the easy answer on that one. Other states, they have exception, which is known as the nonprofit exception. A lot of states say that if a nonprofit is employing physicians and it is run and controlled by physicians, then that's okay. So states like Texas, trying to think of other states that had the exception. I'll use Texas as an easy example since it's one I'm most intimately familiar with, is you can form a nonprofit entity. The board has to be made up of at least only physicians, but the minimum of 3. And they're the ones that are basically controlling the medical decision-making. And then that nonprofit is an entity in which can then do contracts with hospitals. So a lot of the hospital systems here in Texas have these separate nonprofits that are set up. Those nonprofits directly employ those physicians. So that's one way in which it's done. The other way of which it's done is similar to what we had talked about, is you have a professional entity in which one physician owns, say, 100% of, even if they have 50 or 60 docs working there. And then that professional entity enters into a contract known as a management service agreement with a management service organization. And that entity could be 100% owned by non-physicians, meaning that a lot of the PE funds, that's the way they structure those. So management service organizations, they've been around for 40, 50 years probably. When I started first practicing, I was actually an in-house counsel for a management service organization based out of New Orleans. And they've been around years before I started practicing. So again, this is not something that's brand new to the system. The concept is, though, this management company, what they pitch to the physicians is, hey, we're going to come in, all of the day-to-day running of your business, that is the backbreaking, finding the right employees, finding the right space, doing your marketing, finding the right EMR equipment or whatever it is that, and making sure you're compliant with the regulations, all that stuff. We, the business people, we're going to make that happen for you, doc. All you have to do is walk in, flip that light switch on, and start providing medical service. So high level, that's the concept behind it. I've seen it work extremely well, and I've seen it go really bad. So for instance, I have physicians who own their own management service organizations. They do that, some of it for some asset protection planning, depending on their states with that, which have bad malpractice claims, but other which they've done so well, other docs come to them, knock on their door and say, how do you do this so well? But I don't want them to know that you're going to help manage my practice. So they form a separate management company that these doctors own, and then they'll go in and manage other doctor clinics. So it's still owned by doctors, and meaning that they don't have to be physicians to do it, but they do it because that's a way in which they're growing their business side of it. So that can be done that way if you wanted to. But to your initial questions, those are the two main ways we see it in which non-physicians kind of partner in strong corporate practice of medicine states with physicians.
And in that kind of situation, for instance, working in a not-for-profit in a strong corporate practice of medicine state, say a physician finds himself or herself absolutely on the hamster wheel, doesn't have any say in their staffing level or the quality of the staff or the competence of the staff. Basically, the physicians feel like they're being run into the ground and that it's not safe care. And I think this is a pretty common scenario. What's going on there? What recourse would a physician have if they realize that their day-to-day practice, there is very little autonomy there, despite agreements early on or expectations that they would have an independent practice as far as their clinical decisions?
So a lot of times, depending on how they're employed, either directly from the nonprofit or through another entity, a lot of the times it says, hey, we, the entity, we're going to do certain things. And we, the non-physicians, we're not going to assert control over those medical decision-making. And when I have a phone call from a physician saying, hey, they are asserting control, the first thing you do is dust off the contract. What is the process that you go through to notify them this is not what we agreed to? So is there a notification saying, hey, what you're doing is outside the scope of what we agreed? So for instance, if the agreement says they're not going to control clinical decision-making, they're controlling, that's a breach of our contract. And so let's make that a notification. So you take the first step. Other places, depending on, again, how their staff, so there might be medical bylaws for their staff that they want to go push it up to the proper chain. And so follow whatever the guidance is that's there. That's the first step I always recommend, because what you don't want to do is go outside of whatever you agreed, because a lot of docs, they immediately want to go punch the guy in the face. And when I say that, it's punching them either by, unfortunately, I've had some docs physically assault people, but I don't recommend that, by the way. They want to go sue them.
Okay, fine.
Yeah, they want to go sue them. And I'm like, okay, well, if you're suing them, that's because in the concept is you've already gone through all the administrative processes you can before you sue them. Unless, of course, there is something that is so egregious that is that you have to immediately terminate the agreement because of patient care or patient safety, because that's where, I won't bore the audience too much, but there's something called a temporary restraining order, which is the damage is done is irreparable, meaning that you can't fix the damage. If the damage is something that is money-based or is not irreparable, you still have to go through the administrative process. So a lot of times docs jump the gun, as I say. They go immediately to file a lawsuit, and the court's like, well, did you file A, B, or C? And the doc's like, these are the reasons why it's all bad. And they're like, well, those all seem like financial. They don't seem like it's irreparable harm to the patient. So go back to the drawing board. And so now they're still got to go back to where they started and go through that process, which is now delayed because you filed a lawsuit too early. And I'm not saying this is an easy decision. So hopefully when you are speaking to someone in this world, they're counseling you as to here's the rules. Here's the only way to jump the outside of this rule because there's some irreparable harm. And let's really make sure you, doc, understand what that means. Irreparable harm is not because you're mad about a staffing issue, or you're mad about the equipment they wouldn't buy, or you're mad that they kicked you out of your office and put you in a smaller office. That's not irreparable. Irreparable is they're making you operate on patients that you shouldn't be operating, or they're making you do egregious tests that are harmful to the patients.
Right.
Those are the kind of things that the patient's safety is at issue. That's the thing that a lot of courts catch on real quickly. So those are the things we look for. And so again, going back to what we started, before you enter an agreement, hopefully you have eyes wide open going into it, knowing what you got. And then when there is a moment in time where you're trying to figure out how to get out of it, hit the pause button. And look, I've had this story where the docs are like, well, I have unlimited money. And I said, it doesn't matter how wealthy you are, it's the time. Understand the moment you throw out the lawsuit, it's going to be a time suck. And I've had many clients who are very well off. And I always counsel them the exact same thing is they always tell me, well, money's no object. And well, it eventually will be, number one, but it's the time that you're not aware of. And the best way I can describe a lawsuit is the moment that lawsuit's filed, it's basically like getting your car up to 70 miles per hour and taking the steering wheel off and throwing it out the window because you don't know which direction it's going to go after that. So as best you can, you try to internally work through the process. You try to figure out what are the ways in which I can remedy the situation. And finally, if it's not remedied, maybe that's the time in which you can then move forward with the lawsuit. Again, eyes wide open, understanding the risk associated with that.
And it sounds to me like a lot of your clients might be in fairly empowered situations, groups of 20 or 30 that had their own practice and then agreed to an MSA with an MSO, a management services organization. And so they can get riled up and they remember what was said and what was written down. They might even have been a party to what was said and what was written down. And I think that the people that I hear from more often are pulled into large organizations, working for large corporations that most of us are familiar with. And they don't really remember the specifics of the contract or how to get their hands on the contract. I always tell people, go find out what was written down, what was written down and where is it? And I think that for some of these folks, they are not coming from a sense of being empowered. They're one of hundreds or thousands of physicians in a system. And they're working in a way that they feel is over time harmful for patients with a rapid schedule and no time to think and doing endless prior authorizations without support staff to help with those sorts of things and a rapid road to burnout. And so can you address that physician who has been, it could be an academic structure or a large healthcare system, how would they go about even getting their hands on some of the bylaws and some of the basic contractual language?
Yeah. So I'll start by taking a step back.
Okay.
The one thing I tell every physician, or especially people in their fellowship or resident program, and the best way I describe it is you have money that you went off and bought a Lamborghini or a Porsche, the car that you always wanted, and you spent $250,000 on that car, but then you decide not to spend the extra few bucks to get it insured. Then you wreck it and you're not insured. That's how I feel about doctors who graduate and they don't hire, and I use the term healthcare attorney to analyze their contract. And the reason why I say that is they just go off and they sign it and they have no idea what they're getting themselves into. They have no process of recording what they have. They don't know what they're getting into. And when I get the phone call, well, I don't have my contract. I think this is what I signed. And I'm afraid to go ask the hospital or the system for that information. What's impossible for me to help them? I mean, literally, I have no basis as to tell them, how do you give notice? What was the expectation set for you? What did they agree to give you? What did you agree to give them? So let's take a big step back. Yes, you can always go to your system. They should have a contract on hand. A lot of physicians are afraid to ask for it, but it is your contract, and say, hey, I moved and I lost it, as I always say, or, I had it when I was a resident and somehow it got misplaced. Medical staff bylaws, often for larger systems, they're online now. So I've been pulled in stuff and I just pull it off their direct websites and it says the date in which they're dated, when it was approved, who approved it. And so that's a lot easier to find than when I first started practicing. Websites were relatively new. So, you can find the information pretty quickly now if, you're those big systems. The other thing going back is these big systems, when I review their contracts, most of the time I'm explaining to the doctor what they're getting into. As you said, if you're one of 100 or one of 200 or one of 300, they're not changing the contract. They might change a few elements. And when I say a few, it's like your comp here or your vacation or whatever it is. But they basically always say, this is what our contract is. And if you want to work for us, you're signing it. And so at least they have eyes wide open going into it, knowing what they're getting themselves into. And then the other thing is talk to other doctors in the system. What are they saying about it? Find out how much they enjoy it. What's their vacation like? What's the staffing like? And this, doctors, if asked in the correct circumstances, they'll tell you the truth because they're either miserable or they love it. And they'll be pretty upfront about, if they're miserable or if they love it. So to your actual question now, which I know I had to go a loop to get there, which is, yes, I mean, you still go back to if they're miserable and they go through all the steps, eventually I've had the hard conversations is, if they're not going to abide by their contract, which sometimes they don't, and they're not following the medical staff bylaws, you have two choices: sue and still be miserable and stay, or leave. And it's a tough decision because a lot of times you're embedded in the community. You've been there for a long time. There may be a non-compete, depending on your state, associated with leaving. And I'm not ever going to say it's an easy decision. As someone who's moved states before, moving and restarting is not something anyone wants to do, whether or not you've been practicing 2 years or 20 years, but that is the unfortunate aspect. The last thing, which I know docs have done, is they then try to pull in, this is wrong what they're doing. I'm calling the reporters, or I'm calling the state attorney general's office, or I'm calling an outside, DA's office. Be really careful when you bring in outside authority. I've seen that go really poorly for everyone involved. Poorly in the sense of the hospital ended up firing you and suing you for any damages because you may have violated some confidentiality aspect of it, releasing patient information that you weren't allowed to, or other things. You may have brought the reporters in, and then it ends up being that they do a deep dive on the hospital, and then the hospital loses monies and they fire you. So again, be really, really careful when you bring outside sources to attack your system, because the exposure could be more damaging than you anticipate. Similar to litigation in that sense. So again, going to your question, you try to fight it correctly internally. And if you can't adjust it and you feel like patient safety or your job is at risk of meaning that the medical board can go after your license, then you have to make that hard decision that you did everything you could, which is important, but they were not willing to work with you.
Yeah. There is some sense in some of these larger systems that all of the physicians are in the same boat, that they are in a situation where they're really not able to practice as professionals and spend the time that's needed with patients. And so it's a matter of hundreds of physicians being in this situation. Is there any way to take on that kind of structure? Because I think generally all the language is in order when it comes to the organization. The language is in order. What's written down is protecting physician autonomy, but the reality of it is not. And I'm wondering, is there some way to take on this issue in a bigger way? I think there's for-profit organizations that have a lot of physicians that work for them as well, but probably through these management services organizations that you've described. But is there a way to take it on?
Sure. So one way, obviously, is if all the physicians are in agreement, they take it up collectively to the medical staff and say, this is not right for these reasons. Sometimes they will pivot on that. I have had recent phone calls with docs who are so upset at this one system. They're jokingly, but I don't know how far off. They're like, we're thinking about unionizing because what they're doing to us is wrong. I've heard that before, but you have to get everyone on board. By the way, I'm not recommending unionization, but if the concept is all the docs generally have to be in agreement that something is wrong to really push back against a system. And what I mean is if you're in a group of, again, large system, there's 200 docs with the exact same specialty, and 5 docs are upset about it, they're not going to listen. If 150 docs are mad about it, they're probably going to listen because they realize maybe we are outside the standard of care, or maybe what we're doing is pushing this burnout and we're going to have a whole bunch of doctors, resign and leave. And that's not what we need. Again, a lot of these conversations I've had since COVID has shifted because especially the ones on the front lines that I speak to, they're just burned out just in general. And then they're mad as hell as to how the system's treating them on top of that. And so there's no perfect answer as to what's the best way to deal with it. And sometimes it's an individual decision. But if you have enough doctors who are in agreement with you, then you maybe might be able to turn the system to think otherwise.
Yes. I think the famous one during the COVID era has been Blackstone Team Health with, I think they've got 20,000 physicians, but they fired Ming Lin, the ED doctor up in Washington State, when he was he posted on Facebook asking people to help him get some PPE for the ED staff. And he ultimately got fired, apparently, because that made the people uncomfortable, that it was bad PR for the hospital. And I think hellfire rained down a bit on Blackstone, although they can probably tolerate a lot of hellfire raining down. And I think that these private equity groups, these huge organizations like Blackstone and KKR that have hired many physicians in certain specialties where it's possible to really monetize their work, they kind of buy the docs out, give them a bunch of money up front. And then the physicians are employed, probably again through a MSO. But then we hear that it's a big time bait and switch after that, with the income for the physicians going down and the lifestyle and loss of autonomy becoming extremely onerous. Do you have any thoughts about any of that? Or is that something I shouldn't even be asking you about?
No, absolutely. So I've seen it in lots of different directions when it comes to that. So I was representing a group recently. Hospital came along. They had I guess there were about 75 physicians, mostly on the surgical side, a whole bunch of different specialties. But the senior group of physicians decided that they were ready to get bought out large system came along, offered money to them. But the younger docs, the doctors from the below 50 or the ones just recruited were real upset by this because they didn't want to work for a big system. And so it ended up being a pretty big deal where several of the docs ended up splintering off and forming multiple smaller groups just because they just didn't want to go into a large system, which obviously devalued the purchase price. Because if you're buying a group anticipating that this many docs are coming, for every doc that kept leaving, it was going to devalue the group, which then, as you can imagine, if you've been partner with someone for over a decade, which some of them had, and now you're saying, I'm not joining that group and I'm going to hurt your quote buyout, there were some real hurt feelings and very angry doctors' emails that I had to go through. And luckily, the attorney on the other side, I've known literally for decades. So we never got pulled into it. But the doctors certainly, it was very personal to them both ways. A, I never wanted to work for the system. And B, you're hurting my buyout as I try to get ready to retire. So that does happen. And it does splinter groups because some groups just don't want to be bought out by these big groups. Other times, I just did a deal where they all seem to be very interested because the concept is, hey, we're going to buy you for X, but we plan to grow this over the next 5 to 10 years and then resell it for Y. Someone comes along and say, hey, doc, we're going to buy your practice for $10 million. So they hear 10 million, right? Oh, wow, 10 million, 10 million. And then when it comes to the purchase price, they're like, well, we're paying you 6 at closing. And then we're giving you 4 million in shares of an entity that we may sell down the road. This goes back to understanding if you are interested in doing a private equity deal, what are you truly getting at closing is the first question you should be asking versus understanding what the purchase price is. Because the 4 million that may come, that may never come because if they never sell it, the value of that new entity could be much less than that. So those are the kind of conversations we have with physicians who are interested in working with PE. And the last piece is, I think, where you were heading is understand that you have been employing yourself. You being the other doctors, you all have been employed by yourself. You have independent thought. The moment you sign up, again, I've seen it done very successfully with an outside PE or MSO, there's a shift in mentality or system because there's certain decisions you used to make all the time, you being the practice, versus now those decisions are being made by the business side of it. And so long as the business side doesn't come onto the clinical side, again, I'm comfortable with it because there's legal ways for it to be structured, but I want the physicians to have eyes wide open, understanding what they're getting themselves into.
And do you think there is a bright line between the clinical side and the business side? I mean, I think of things like schedules and hiring staff as, wow, does that ever have a big impact on day-to-day practice?
There is a bright line, and it's easy to see on certain aspects, right? So who's physically clearing the patient for an examination, who's determining the diagnosis and coming with treatment, who's prescribing the information that's required. Where it gets tricky, and this is the part where the outside resource, the big system or the PE might say, hey, here are the people we're hiring. Well, ultimately, again, you, the physician, if you're working with that RN or MA or whoever the person is who's catering you, you still have ultimate decision saying, well, you can hire the person, but they're not touching my patients. They don't know how to hold the needle correctly, or they keep messing up the initial history, or they keep doing this wrong. And so you have to put your foot down that person can't touch your patients, because if that patient is harmed, you, the physician who's overseeing that person, is ultimately responsible for that. Or if another deal I'm involved with, they're asking you to use a certain equipment is for crap. It doesn't work well. It doesn't give me the results. And I don't care that you own a company or you already cut the deal. You should have come talk to me beforehand. I'm refusing to use it. So again, that's another situation that I see is, so if it's a copy machine or the Dell versus IBM, that's really that's a business decision. But if that machine is being utilized to then impact the patient care, that's definitely a situation where you want to have that participating physician to look at and determine, is that a good use of the funds? But more importantly, can that be used to treat the patient the way it's supposed to be done?
Okay. And I keep using the example of scheduling, and maybe this is significantly a primary care issue, the hamster wheel that many primary care physicians feel that they're on. And I'm wondering, does it seem clear to you that the schedule and the number of support staff would be business or clinical or gray?
It's gray.
Okay.
It's hard because most of the time when you see these contracts, you're going to work for us full time. For see how they define full time. They then say that they're going to provide you the support staff that's necessary to run those services. So again, those are all the things you start looking at. The scheduling, I haven't seen anything come up before where it says that you controlling their schedule, you're now making clinical decisions. You're saying, hey, if we're paying you this much money, we're expecting you to be here 5 days a week or 4 days a week or 32 hours or 40 hours or whatever it is. A lot of time that's already spelled out in the contract. So that shouldn't be something that blinds them. For staffing or equipment, the agreement should be talking about whether or not that's what's consistent with the standard of care. And so if the persons aren't doing that and they're not providing it, that does, I mean, I have doctors who refuse to go to certain hospitals because they say the support staff is horrible there. They have these state-of-the-art facilities, but they have horrible surgical scrubs that scrub in with you. They don't know what they're doing. They don't know how to do spine, or they don't know how to do this. They don't know how that. And so I was like, well, stop going there. Oh, okay. Because if they won't accommodate you, doc, and you think they're going to ultimately harm your patients, I would recommend you stop going there.
Yeah, I think that is a good example. And I wonder if you've seen a situation like that where the physician then ends up getting disciplined or terminated for being disruptive.
Yeah. Yes. So you had a perfect story earlier about a doc who was asking for help. The systems don't like if it's that one doc who's making all the fuss, that you, the doc, first off, going back to be professional and follow the rules as best you can. My docs who, I'm not picking on surgeons. I just feel like I guess I get pulled into all the surgical deals. A surgeon, obviously, their whole job is to have independent thought and to work through processes when bad things happen inside a surgical room. And that's where a lot of my complaints from the hospitals go against docs is, they're yelling at the staff because they're incompetent, and then the staff writes them up. Or they're yelling at the administrator who shows up inside of a surgical room and says that they can't use a certain tool. And he's like, he may use the F-bomb that he is the effing surgeon, and you just graduated from MBA school, don't know what the F you're talking about. That may have happened a time or two by...
that sounds like a quote to me.
I may have read that before in a report. And, conceptually, again, that goes back to, well, were they making at that moment in time clinical decision, or was that a quote policy of the hospital versus a good decision in the hospital? So these are the kind of things where you're walking these fine lines and says, well, the medical staff bylaw says you can't do that. So if you can't do that, doc, and you want to do that surgery at that facility, then you can't do it because all your other doctor friends agreed to that. Versus the MBA person, again, my sister's an MBA, so I'm not making fun of MBA people. The non-physician making a determination about what equipment you can use or what things you can use for the betterment of your patients, that, again, crossing over the line. But just because they cross over the line doesn't mean you can be disruptive, throw tantrums or whatever it is to the individuals. And
can physicians get in trouble for aiding and abetting the ban on corporate practice of medicine if the physician is a frontline doc trying to keep up with the fast pace and making all the phone calls and grooming their own patients? They're existing in an environment that is not consistent with what's written down, where their autonomy and support staff's not as promised. In that situation, can the victim of this scenario also be accused of aiding and abetting?
Unfortunately, yes. So
wow,
you, the physician, you're ultimately responsible for the care of your patients. The concept is, if you think that the standard of care is not being followed, you have to be advocate for your patients. And again, and by being an advocate for patients, you're trying to protect your license. So again, let's go back to your scenario. If you have been bringing up over and over again that this is not correct and you need to make these changes, how will the medical board view if a patient ends up being an issue? So I can tell you from the malpractice lawyer side, they hate it because they said, why did you keep operating there if you knew that it was a bad situation? From the medical board side, a lot of times, if you, the physician, are the one trying to right the ship and you have good evidence of emails or being in front of the medical board explaining why, and there's minutes from that will help your case in front of the medical board. And going back to your question, medical board investigations are often open because bad facts showed up to the medical board. Our job as healthcare attorneys, when we respond, we want to respond with the good facts as to what really happened. So again, normally people who file complaints are angry people. They're your angry patient, they're an angry former employee, they're an angry former partner or angry competitor even. And so when they're submitting the facts, they're putting you in the worst light. Your job is, if you've been doing everything correctly, a good medical board will review all the information in front of them. Your job, well, hit the pause button, go hire your healthcare attorney to help you. Do not answer it yourself, please. I cannot tell you the number of times that physicians have answered themselves and put themselves in a worse situation. Your job at that point is to clear the air correctly, make sure that whoever the investigator is, who's sometimes a doctor, but rarely, normally they're former RNs who the initial line or who the investigators are. So you're trying to explain to an RN why what you did was appropriate. You're going to spell it out in a very kind way. Again, we're not going to tell them to go F themselves. We're going to be very upfront, kind.
Oh, no, wait. We're not?
We're not.
Okay, gotcha.
Showing up with blazing guns and telling the medical board they can go stick it. Trust me, that's just asking to be investigated. So please don't do that.
Okay. I was going to ask you about something that drives you crazy that you've seen with physicians with regard to corporate practice of medicine.
I think the two things that drive me crazy, one is that they say everyone does it. And they think because everyone does it, it must be legal. I mean, the number of times I've heard, Brad, you don't know what you're talking about. Everyone does it. I always answer, yes, I do understand that everyone does it. That everyone does it does not make it legal. And then the second one is they'll hear it's never enforced. And again, that's a complete lie. Are they enforced? Yes. Is it rare that you're going to get picked off? Yeah, probably. So that goes back to our risk, right? Are you willing to put up your $250,000 Lamborghini that you worked so hard to get without insuring it? Because it's very rare that you're going to crash it, right? There's a very rare chance you're going to crash it. But if you're willing to do that, great. And that's the process I always try to have someone walk through or think about, okay, how do I feel? How comfortable do I feel with that? And the last thing I will say is I've had this conversation over the years. So I'm licensed in, I guess, 5 states right now. I represent clients from coast to coast. I have unfortunately had many clients where I say, do you want to be the test case? And by the way, I've had many clients who were the test case. It's never a great spot to be the test case, because if they decide they want to get skins on the wall, they're using you to tell everyone, hey, guess what? We're now enforcing this rule. Or, hey, but guess what? We think this arrangement's illegal in our state, and now we're going to blow up this deal. And so where doctors, they go back to everyone's doing it, so it must be okay. Therefore, I'm just going to sign anything in front of me and I'll be fine. And they don't stop, hit the pause button and really think about, what do I need to worry about? What is the risk about doing this deal?
I'll even pile on by saying, know what's written down. Find out what's written down and hang on to anything that's been written down that you've signed. Thank you, Brad Adatto. I so appreciate your time here. And I hope that I can get you back on again, because I think there are a lot of other areas that it would be terrific to dive into.
Appreciate you reaching out and us having a chance to spend some time together. For those who enjoy podcasts, I think you already plugged my podcast in the beginning, but the Legal 1-2-3s with Brad Adatto is definitely a way in which you can hear our stories. And those who want to see my pretty face, the face for radio, you can always go to our website at www.byrd.com and check us out. You can follow us on all the different social media outlets where we post, or even subscribe to our newsletter. We have a weekly newsletter. But again, I really want to thank you for reaching out and asking me to be on your podcast. I really enjoyed our time together today.
Thank you, Brad. I really appreciate the time that you've taken today. And I appreciate getting the benefit of your expertise. And listeners, I'd love to hear what you thought of this episode and what else you'd like to know about the corporate practice of medicine. What have you run into? What questions do you have about the interpretation and the enforcement? Perhaps most importantly, the intention of the corporate practice of medicine laws and statutes. Are you in charge of clinical decisions for your patients? Send me a voicemail or email. You can get to the License to Lead webpage through the show notes, or go to fakeconsulting.com and click on the podcast page. And while you're there, go on ahead and sign up for our newsletter. It's pretty fun. As always, thanks so much for all of your care and caring.
Thanks for listening to the License to Lead podcast. Be sure to visit licensedtoleadpodcast.com to join the conversation, access the show notes, and sign up for our newsletter. Leave us a message with your provocative question or your thoughtful comments. You might inspire a future episode of the License to Lead podcast. Thanks so much, everyone.